some really exciting panels left in the day. So this panel will be addressing updates in class certification, and then I think really one of our star panels to end the day will be dealing with the class action implications of two-sided markets and antitrust litigation. So to get started with this panel, when I started talking with Matt and Nathaniel, we just looked back at the various cases that have come out over the last year, since really last year's conference, and the implications that they've had for the class certification process. So let me just go ahead and introduce Matt and Nathaniel real quick, and then we'll get started. So I've actually had the privilege of working with both Matt and Nathaniel over the previous few years, so I know them very well. And thank you so much to both of you for joining me with this panel.
Thank you for the invitation.
So Matt, we should actually be referring to him as Dr. DalSanto. He has his PhD in economics from the University of Minnesota, but he also has his JD from Berkeley, and he's currently an associate at Winston and Strawn, and so he obviously has a legal practice, but he also oversees the economic practice, or some of the economic analyses that Winston and Strawn undertakes internally. I've actually met Nathaniel when he was at his previous firm. So he was with the firm of Curtis Mellet, and we were working on a large antitrust class certification matter there. And then I guess within the last year, you've moved over to Robbins Kaplan.
Yep.
So, okay, well, let's go ahead and get started. And so just, almost as a housekeeping matter, but one of the main cases that did come out that relates to class certification last year is China Agritech, and it relates to the tolling of the statute of limitations. And so Nathaniel just agreed to briefly summarize it, and then you had also picked up on the fact that Justice Sotomayor had an interesting dissent in that, or concurring opinion,
right.
And that there might be some interesting language in there.
Yeah. So, afternoon, everybody. I know this is the sleepy time of day, so we'll try to spice up class cert to the extent we can, and we'll do so by starting with a unanimous decision, which is the China Agritech decision. This is about American pipe tolling, and specifically for whom the American pipe bell tolls. It's terrible, I know. So American Pipe, just brief review, says that the statute of limitations is tolled for once a class action is filed for subsequent filed actions, arising from the same facts. And the question in this case was, does the filing of a class action toll the statute of limitations for subsequently filed untimely class actions, or only for individual actions? And the Supreme Court 9-0 says only individual actions. This is, in a way, sort of an efficiency policy-based decision. It's, the class action mechanism is intended to incentivize early filing, early resolution of class cert, get all these claims together and resolved. And that those purposes aren't really served if we then allow a subsequent class action to be filed. The reason that it tolls it for individual actions is because we're trying to get those efficiency gains of deciding class cert early. So economy of litigation favors delaying individual claims until class cert has been denied, but with class claims, efficiency favors early assertion. And I think as a practitioner on the left side of the V, where we are trying to become class counsel in a lot of class action cases, it makes sense that you want to file early. As a matter of practice, we wouldn't wait until there are statute of limitations problems. We want to be one of the first filers. So I think this was sort of an uncontroversial decision, except, this is the asterisk, Justice Sotomayor concurs, and she says, this makes sense in this case, which is a securities case, because the PSLRA, which is the Private Securities Litigation Reform Act, has certain provisions that Rule 23 doesn't have that makes tolling inappropriate in this case. The PSLRA has a requirement of pre-certification notice to absent class members. Under normal Rule 23, notice only goes to absent class members after the class is certified. Rule 23 also doesn't contain a process for the district court to choose between various candidates for lead plaintiff. It delegates a lot to the district court, whereas the PSLRA says you have to choose the most adequate representative of the class, not just deem whether this lead plaintiff is an adequate representative. But really, that was the only source of controversy in the case, and I think this is a pretty clear rule for practitioners going forward.
Okay, well, now that we got through that case, why don't we try to tackle something a little bit more controversial? And so many of you may be familiar with the Azikal decision that came down middle of last year, and it really wrestled with this idea of uninjured class members. And I'm fairly certain that Matt and Nathaniel, as lawyers, will have a lot to say about it, but also I, as an economist, have a lot of strong feelings about that case as well. So, Matt, could you just give us a brief overview
Sure.
of the facts of that case and what that case stands for, and then we'll see if Nathaniel might have a different take.
Absolutely, and I'll try to do this as briefly as possible. So there was a drug manufacturer, Warner Chilcott, that pulled one of its products, Azikal, from the market just months before the drug's patent protection expired. And at the same time, it had introduced an identical substitute drug called DalSanto, the patent protection on DalSanto, which ran for several more years. And then there was a second drug called Azikal HD that was already on the market and also had patents that were expiring much later. So plaintiffs had alleged that the coordinated entry and withdrawal of these drugs led to the prohibition or the prevention of the introduction of generic drugs that would have been low-cost alternatives to these drugs. And so they sued, claiming that essentially that those who purchased Azikal as well as Azikal HD paid an overcharge, paid too much on those particular claims. And the district court went ahead and certified the class of purchasers of DalSanto and Azikal HD. In doing so, the court found, as I think the First Circuit called it, a factual approximation, that 10% of the actual purchasers of these two drugs would not have been injured because they would have purchased those drugs regardless of the fact of whether there was a generic that had been introduced in the market. So there is, roughly 10% or so uninjured class members who were unknown at the time the class was certified. And so the First Circuit then, the question before it was, can a class be certified in this case, even though injury in fact will be an individual issue, the resolution of which will vary among class members. And the First Circuit found that the approach that was taken by the district court was at odds with both the Supreme Court precedent as well as that of the First Circuit, and they reversed the court's decision on class cert. The First Circuit analyzed the decision under the predominance prong for class certification. And they said that, which is obviously that common issues must predominate over individual issues in order to certify a class. And they said the aim of the predominance inquiry is to determine or to test whether any dissimilarity among the claims of class members can be dealt with in a manner that is not inefficient or unfair. Inefficiency they described as being the situation where you have a line of tens of thousands or at least thousands of class members waiting their turn to offer testimony and evidence on individual issues. Similarly, unfairness is equally well pictured as an attempt to eliminate the inefficiency by presuming to do away with the rights a party would have, but customarily have, to raise plausible individual challenges on those issues. So, and in assessing the efficiency and fairness, the First Circuit recognized that a class may be certified notwithstanding the need to adjudicate individual issues so long as adjudication will be both, quote, administratively feasible and protective of defendants' Seventh Amendment and due process rights. The district court also sought to address the Nexium decision, which was a prior decision on similar facts, where there was where the prior judgment will be. So it sought to track Nexium, finding that prior to judgment, it will be possible to establish a mechanism for distinguishing the injured from uninjured class members. Nexium had put forth a proposal for how to do that in that particular case. So The court, in addressing the proposal advanced by plaintiffs, said that in a court-approved notice, class members will be asked to submit a claim form along with data and documentation that may be deemed necessary for consideration. The claims administrator will evaluate each claim pursuant to a formula proposed by plaintiffs and approved by the court. But the actual specifics in terms of how that claim administration process would be handled were not outlined. And the court went on to say that one can only guess at what data and documentation may be deemed necessary, what the formula will be, and how the claims administrator will decide who suffered no injury. Nevertheless, the district court was convinced that NXIVM permitted such a scheme. Obviously, the First Circuit disagreed. And then the decision went on to try to limit NXIVM to the specific facts of that particular case, which the First Circuit noted that it was on a rather unusual procedural posture when it came before the First Circuit, that the affidavits, that there was no actual specific position in the record where it could have been rebutted. So they went ahead and tried to distinguish it and said it was completely different in terms of the situation that was before the court and as a call. And so given that there was no indication that the number of contested affidavits would be small, the court concluded the plaintiffs had not shown that the common issues predominated. And the First Circuit went on to quote, reject any invitation to rewrite NXIVM as sanctioning the use of inadmissible hearsay to prove injury to each class member at or after trial. The fact that plaintiffs seek class certification provides no occasion for jettisoning the rules of evidence and procedure, the Seventh Amendment, or the dictate of the Rules Enabling Act. And one other interesting thing to point out and one other point that the First Circuit made was that the claim administrator's review of contested forms completed by consumers concerning an element of their claims would fail to be protective of defendants' Seventh Amendment and due process rights. So plaintiffs' proposed claims process provided no meaningful way for defendants to actually challenge whether an individual would have, in fact, purchased a generic drug. What's also interesting is plaintiffs had a fallback argument, according to the court, where they said that they could establish class-wide impact on the basis of their expert, specifically Dr. Conti in this matter. But the court came back and said that it was not a situation where Dr. Conti's expert testimony, which had established that roughly there'd be 90% market penetration of these generics, again, where 10% did not purchase the original drugs, that 90% could be used to actually establish individual injury. No one could walk into court necessarily with that and say that 90% was good enough for a particular claim. And then the court also went on, and what I find interesting also as an economist, to say the slippery slope that would be present here if you did permit such a situation where if you have a class, and the example is somewhat extreme, but where there were only 50% of class members who were injured and 50% who were not, that it would not be appropriate necessarily for class certification. You don't want to put it in a situation where you risk escalating disregard of the difference between representative civil litigation and statistical observation, pointing out to the fact that class certification is meant to collectively bring individual claims, not act as its own vehicle where it is a representative going after a particular action. And finally, the last thing I'll note, so that in my very brief summary, is that the court also noted, plaintiffs had argued that, in support of that latter argument, that the amount of aggregate damages would be the same. That to defendants' point, it didn't really matter because they were facing the same actual exposure, regardless of who was actually injured, because the measure was an overall average that would take into account those who were injured and who were not. But again, the court said that this deprived defendants of actually bringing defenses against the individual specific claims. So what do I bring away from this decision? Probably pretty obvious. It reaffirms that Rule 23 does not deprive defendant of its due process rights in defending against individual claims, and that courts should not use the class action to group together claims where you have injured and uninjured actual members that have plausible defenses to claims. So let me stop there. I've taken up.
Let me jump in for a moment and really direct this question to Nathaniel. But I know in my own work, I see increasingly plaintiffs making the argument in response to the possibility of uninjured class members. Well, that's something that can be addressed in, say, the claims stage. That once we get in front of a claims administrator, we can sort out who may or may not be able to recover damages. How do you think the as-a-call decision relates to that? Is that still a valid argument going forward, or is as-a-call kind of cut the legs out from underneath that argument?
This is a very interesting decision for a few different reasons. One, with respect to that point specifically, there is the leading Ninth Circuit case on uninjured class members is this case, bless you, Ruiz-Torres. And the court basically adopted a de minimis standard. It said, some class members are uninjured, but the vast majority are injured. That can be fine for class cert. But the language that the court used, some district courts in California, surprise, surprise, have chosen to interpret in a plaintiff-friendly way. And they've chosen to interpret it as essentially saying, this is not a class cert question, because as long as all of the class members as defined were exposed to the same conduct, it is a claims question who actually was overcharged or injured or whatever the injury was versus wasn't. And you can see a lot of areas of the law where this is demonstrably how we do it. In antitrust law, the question is, was this product price fixed? Did the class purchase the product? Okay, we're done. Ish.
I might have a few things to add in there, but understood.
But not only do we not ask, was every individual member of the class overcharged? Some of them might have gotten a steep discount. But we deliberately get it wrong in some ways in terms of Illinois BRIC apportioning liability in a way that most befits the system. Or at least that's what the fans of Illinois BRIC would say. And there are a lot of areas of the class action scheme in which liability is deliberately misapportioned. So for example, if you have a claims process at the end of the litigation, we know for a fact that a lot of class members are not going to participate, and that's going to increase the average recovery, but a lot of class members will go uncompensated. Or you can have a minimum payment to a class member where I was only injured 75 cents, but it costs us a few dollars to print up the checks, so we're going to give a minimum distribution of $5, let's say, which detracts from the recovery that some of the more largely injured class members. So I actually think that's still a legitimate position, and that there are some courts who would agree with that. If I can, I'd also like to branch out into a few other thoughts about this case. So one, I think it's clear that class cert in this case would have been tricky. One of the strongest points the court makes is that you cannot take the average injury amount and then multiply it by the members of the class. If we know 10% of the class was uninjured, you're going to get to the demonstrably false conclusion that 100% were injured when everyone agrees it's 90%. And that's different from the Supreme Court's donning and doffing case, Tyson Foods, where we look at the average donning and doffing time and multiply that by the overall class size, and in theory, we're getting the right aggregate damages amount.
And there's a different legal standard there under the labor laws.
Right. Yes. So you had that problem in this case. But going forward, what do plaintiffs do with this? One, obviously, and this is not super helpful, you want to define your class in a way where you're going to have as few uninjured class members as possible. But isn't there sort of a tension here in that you're also not allowed to define a fail-safe class? So you don't define the class as everyone who was overcharged. You define it as everyone who purchased. and undoubtedly some of them will not have been overcharged. So there's a tension there that you need to resolve. And there's also some discussion in academic circles. There's this great article in the George Washington Law Review that I found after my 4th cup of coffee this morning called "The Puzzle of Class Actions with Uninjured Members," where they argue essentially, which I will articulate as follows. If you certify a class with uninjured class members, you raise due process as an issue. Let's look at due process issues for the defense. The defendant does not want to pay more than their actual liability. Well, they'd like to pay even less. But if we're going to force them to pay, they should not have to pay any more than the actual damage they caused. Once we determine what the aggregate damage to the class is, which admittedly was a problem in this case, isn't the defendant indifferent if I get a few more dollars than I deserve and you get a few fewer dollars than you deserve? The defendant's liability is the same. So it's really not a due process problem for defendants as long as we've identified the aggregate damage level.
Well, can
And
I
I would
jump?
disagree. Just real fast. I would disagree with that a bit. Again, getting back to the Ascol decision and what it was saying about class actions, which is an it's a collection of individual claims. It's not a vehicle in of itself to actually go out. So in terms of just, if you're talking about economics and an indifference between a payout of, X dollars versus one way or the other, sure, but in terms of actual legal claims, I would say no, they're not indifferent because you have people who are differently situated, and as a procedural matter, it's not under the Rules Enabling Act. Rule 23 is not supposed to affect the substantive rights of the defendants who are defending against the claims or the plaintiffs who are bringing the claims. And I think that interpretation necessarily does so and treats it very much as though a statistical class, for lack of a better description, than an individual one where you're actually focusing on the individual claims at issue.
Well, at the risk of piling on here,
Yeah, sure.
I know as an economist, when I hear, I understand what's being said with the aggregate damages amount may be correct. But then my next question is, how do you take that aggregate damages amount and how do you think of recovery by individual proposed class members? How do you take an aggregate number and then apportion it down to the individuals who should be getting recovery? And I think that is one of the issues that we see here in Ascol, is that in aggregate, they generally knew how many class members may have been adversely impacted, but they didn't know which ones it would be. They knew that 90% of the proposed class, but they had no way of telling which 90% of the proposed class. And to my knowledge, plaintiffs didn't, nor could they, advance any sort of methodology to address that question.
Right, and their proposed methodology was problematic. No one wants to have the court reviewing thousands of affidavits, which, as the court pointed out, might be contested. No one wants to have thousands of witnesses showing up at trial. And there was no cognizable set of standards for the claims administrator. If this was going to be a claims issue in this case, there was nothing proposed by the district court saying, okay, here's how you will evaluate who was injured. So clearly a problematic decision. And right now, there's another pharma antitrust case in the District of New Jersey in which the court is grappling with what is the significance of Ascol. So in the Revlimid-Thalamid litigation, which to you Billy Joel fans, yes, that is thalidomide. We didn't start the fire. Great song. If you don't know it, you should listen to it. So there are uninjured class members, and it's the same type of lack of injury. There are so-called brand loyalists in the class, and the court denied class cert on the basis of Ascol. And now on this subsequent round of class cert briefing, what the plaintiffs have done is redefine the class to exclude consumers only as a third-party payer class, which I'm certain the drafters of Rule 23 had Humana and Aetna in mind when they were thinking of who should be benefited by the class action device. And this really goes back to the issues presented by having class action litigation in the first place. Aren't we trying to vindicate the rights of people who had, on an individual level, some small injury that they may or may not have the proper incentives to hire a lawyer and go out and document and prove? And every time we add a new layer of proof at the class cert stage, which, let's remember, is not a merits inquiry, is not a damages inquiry, aren't we just sort of whittling away Rule 23 to nothing? And yes, I know that's always what plaintiffs' counsel is going to say at one of these conferences, but realistically speaking, that, you know, these are classes of thousands of people with, on an individual basis, often minor monetary injury, and we are trying to vindicate a greater purpose here. And if we know that the defendant's conduct caused, allegedly, injury in the amount of X to a group that largely overlaps with, you know, this group of people, I agree, 10% might be too many, and thousands of affidavits might be a bridge too far, but there's got to be some reasonable solution here that is not every having to prove the case before you've even gotten a class certified.
Do you, and this is really a question for either of you, do you think Azikal lays out a line that 10% of uninjured class members is too high? Do you think if there were to be subsequent cases with, say, 15% uninjured class members, or at least an estimate of that amount, that Azikal would really be a gating or a threshold issue?
I think it would be supportive of that as a benchmark at the 10% level, but I also think that Azikal very much focused on the predominance of specific individualized inquiries that would have to take place for those 10%. And so, while yes, I think it's very helpful from a defense perspective, I also, in trying to be fair, think that the court did get into why in this specific situation Azikal, it would not have been appropriate to certify the class because the individual issues would have certainly outweighed the common ones, and they even distinguished that from the case of Nexium. So yes, I think it's helpful, but I don't think it sets out a black letter rule necessarily, as much as I wish it did, I guess, and at even a lower level than 10%. Yeah.
Well, did you have anything to add to that, or?
No, I think Azikal is clearly a good poster child for the ways in which, you were saying earlier this might be more of an ascertainability issue than even a predominance issue, but in the way that defining and ascertaining a class can go off the rails. Right. We'll see in Revlimid if, this redefinition was the magic sauce that the plaintiffs needed. I don't think it really fixes the problem, which is if you have a consumer class, you are going to run into these issues. And class action litigation always involves a little bit of fudging on the margins and a little bit of guesswork. And we know this. And, the push and pull between the plaintiffs and defense bars is always how much of that will we accept in the pursuit of justice for the class.
Well, and that actually is a great segue into the next question I was going to ask, and you actually preempted it to some extent, and that is this issue of ascertainability. And so, I know the different circuits have different standards. The Third Circuit has a heightened standard of ascertainability, for instance. I know as an economist, I often get criticized by lawyers for even addressing this idea of ascertainability, that many lawyers say, well, that's a legal issue. It's not something for economists to address. But I know as an economist, I often have difficulty assessing or evaluating impact to proposed class members if I don't even understand what the contours of the proposed class are. If there is some doubt as to who is in the class and who is out of the class, how do you then set about, from an economic perspective, evaluating that question? And so, what propositions do you think Azikal represents in terms of ascertainability?
I think it says quite a few things about ascertainability, but under the banner of predominance. I think what you're seeing is I read through it and talking about the heightened standards for ascertainability and trying to figure out what are the actual contours of the class, et cetera. I mean, it poses as a bit of a different question, not so much on what are the contours of the class and how is it defined, but whether the individual issues to determine whether the contours of the class outweigh the common issues. And I do sympathize with you, Jeff, being on the defense side, when you have a class definition where it is not exactly clear what the contours of the class are. And I'd say that's not only important for economists trying to analyze the data and the other expert work put forth by those who are bringing the case, but also for the attorneys themselves to know specifically what are the claims at issue. And then I finally would just note too, and I think as you mentioned earlier, there are certain things that I think plaintiffs' lawyers have to say at conferences and defense attorneys have to say as well. But just to state that the blatantly obvious too, while class itself, and this is going a little bit off topic, but more general point, while class itself is not supposed to be a trial on the merits, just the very reality of the situation of large classes being brought, the enormous liability being faced, et cetera. When a class is being certified, it can force a defendant into a position to settle merely because of the potential exposure, no matter how justified they are in believing that their case is correct and they should defeat the particular claims. So, in any event, I just had to throw that in because I forgot to say it a second ago.
Yeah. Ascertainability, the Third Circuit's heightened standard seems to be losing a little bit of favor in that I think a lot of the decisions in recent years have stuck with the more traditional, simple understanding of ascertainability means define the class using objective criteria. And really both sides, I think, are benefited from that approach because we are able to find our class members. We both agree on the terms of what we're discussing here. And if you have an antitrust class action, you generally want to have a class that's defined as people who purchased X between dates A and B, right? And same with securities, people who purchased this stock. So usually I think you should be aiming for the most objectively defined, straightforward class you can be. And I think everyone is better off if you do so. And it staves off these issues like uninjured class members and these fact-finding questions that should not be a part of the class cert inquiry don't have to be if you define ideally if you define the class well from the beginning.
Well, I was going to move on to another case unless either Matt or Nathaniel had any final thoughts to share on Azikal. So, well, let's move on to our final case, and I should note that this last case was really motivated by an excellent paper that Nathaniel co-authored with some of his colleagues at Robbins Kaplan. So it was published in Antitrust. I guess it's coming out tomorrow officially, right?
Yeah, well, it's been published already, but yeah, tomorrow the PDF can be distributed.
So if anyone's interested in reading the paper after this discussion, by all means, please get in touch with either me or Nathaniel. But the paper deals with the Sally case, and my understanding of that case is that it deals with whether or not evidence that might or might not be admissible at trial, or what is the relevance of evidence that may or may not be admissible at trial? Can you rely upon that at the class certification phase? So I think I probably butchered that description. So let me turn it over to Nathaniel and let him describe it. And then I think both Matt and I have some of our own thoughts on this.
Sure. I'll try to brush through the facts pretty quickly on this, but this was a California law wages and hours case in which there was an argument by the defense that the class reps were not typical or adequate class reps. And in support of a finding of typicality, the plaintiff submitted a declaration in which I can't remember, I think he worked for their company, had gone through time records and wrote a declaration saying, yes, these two named plaintiffs had their hours undercompensated on these dates. They worked this number of hours, but they were paid for this number of hours. And
The paralegal at the law.
it was a paralegal, yes,
Paralegal
at the law firm. That's it.
Because that's related to one of my points I'm going to bring up in a second. So
Wonderful.
It's critical to note that.
Excellent. And the district court denied class cert and held that it could not, it struck the declaration as inadmissible at trial and said we can't rely on this inadmissible declaration in deciding class cert. Ninth Circuit reverses, says, throws in the usual language about class cert is not merits, this is not a fact-finding exercise, and that even evidence, even if it's inadmissible, if it goes to the Rule 23 factors, it's appropriate for consideration at the class cert stage. And there's not really a circuit split on this as such. There is a Fifth Circuit decision saying in dicta that you should only rely on admissible evidence, and it claims that other circuits have ruled the same way, but then it doesn't cite any such cases. from our research when we were writing the article, it looks like the Ninth Circuit is really leading the charge on this question. And I think we were discussing this a bit. This is a good decision for lawyers on both sides in that it gives us a freer hand for what we can bring into the class cert briefing. We're not just limited to, we don't have to, first of all, resolve federal rules of evidence shooting matches at the class cert stage. We can put that aside and say, here is the evidence that you, the court, will consider relevant in evaluating the Rule 23 factors. Let's do it. So I think it was a persuasive decision.
Well, and that was going to be my follow-up to Matt, that when I read this decision, I don't see it as being plaintiff-friendly. I see it as Nathaniel pointed it out, helping both sides of the V. So what's your thoughts on how defendants might use this?
Very similar, but a little bit different, which is that in Sally, in the particular case, you had a plaintiff's firm, paralegal, going through time records to try to come up with some basic statistics. And statistics related to the actual various classes. I think there were 7 or 8 or 9 proposed classes over various issues in terms of how they had been paid. And I guess my concern is I do want it to be acceptable for, in terms of class certification, whether in terms of a motion or an opposition to that motion, for it to be permissible to attach a declaration or an affidavit in terms of support of some particular point. I think where I differ a little bit is I would adhere a little bit more closely to what Rule 56 says in terms of an affidavit, more for summary judgment, which is that the actual person making the declaration actually has personal knowledge of the facts on which they're declaring about or speaking about, and that those facts would be admissible in evidence later on. And so I think here my issue with this case is I think it sort of gets it right in terms of you don't want to just completely say anything that's inadmissible at trial, whether it's a declaration or otherwise, should be completely thrown to the side in terms of class cert. But I also think it needs to be a little bit something more than just going through and actually having a declaration, where in this case, and why I brought it up earlier, is a paralegal who had no personal knowledge of these particular records, of the time practices, et cetera, writing a declaration, going through saying this is what the amount of actual overtime was. So I agree. I don't think we need to go so far as to say only evidence that would be admissible exactly that way at trial should be used in terms of class certification, but I have a little issue in terms of this particular case.
Well, Matt, what I hear you saying isn't a whole lot different than just evidence generally. That I know experts, from my perspective, experts routinely get their opinions excluded for failing to vet the sources that they're relying on. That oftentimes you hear experts, might pluck a document out of the record and start relying on it without actually knowing the basis of its preparation and so forth. And so it sounds like what you're really saying is that these sorts of materials need to be thoroughly vetted before they can be used.
And one could argue that Sally's decision, as you go later on, decision does actually say, you start talking about the weight of things in consideration. It does get into that a bit, but I still, yes, I think you're right, Jeff. I would note, though, and draw a distinction between what happened to Sally and an actual expert. I still think in terms of actual expert testimony, whether on plaintiff side or defense side, that should be evaluated under Daubert, and that if it's excluded, then that testimony should not be pulled in or considered for purposes of class certification. And
what you're describing, I think, is the majority rule. Yeah. Just one little button I would add on this case. I think it's good for the sides are equally benefited, but plaintiffs are benefited more equally than the defense in that we have the burden at class cert. We have the burden of proof overall, and anytime you're expanding the range of evidence that can be brought forward, then the person with the burden is better off. So I think both sides have some comfort to draw here. But since the admissible evidence is often in the defendant's possession, the plaintiffs are breathing a little more easily.
Well, and I know from the perspective of an economist, oftentimes after will have spent some time researching the market and understanding who the various players are in, say, the distribution chain, that we will have strong suppositions about how that market actually functions. Yet there may be some gaps in our knowledge. We believe something to be true, but at deposition, if someone said, well, prove why you have that belief, we would be unable to do so. So it isn't uncommon for the defendant side, for defendants experts even, to request declarations or affidavits from market participants just to fill in some of the gaps of the knowledge. And so I would almost say that going out and seeking these forms of evidence provide a more complete understanding. It allows both sides to argue their cases with more precision or more specificity than might otherwise be available within the actual record. So I think it simply leads to a more accurate understanding of the case at issue. Anything else that we wanted to discuss about Sally? Okay, well, I think we have about 7 or 8 minutes left, so by all means, we would love to entertain any questions that you might have. I know class certification can be a riveting topic, so feel free to fire away if you have any. Robin.
So I want to go back to the discussion about the uninjured plaintiffs, and what I want to hear is your thoughts about how that might affect the way you think about the low response rates when you actually go through and you have a settlement, or even if you had an award, for example, and you find that the response rates from the potential class members is so low, like we heard 1.7%, and yet here we might be worrying about, that there might be 10% uninjured class members. So please comment on that.
Yeah, I think this is something that rubs me a little bit the wrong way in terms of being more form than substance. When you actually get to the point of apportioning either a judgment or, in the vast majority of cases, settlement proceeds, a lot of people in the class are never going to get their money. And the remaining members of the class, some of them will get too much, some of them might not get enough. There's a lot of messiness in this process, and to hone in on this one particular aspect and say, well, this is unfair to defendants. As I was saying, if you know the aggregate liability, then we're really more concerned about due process for the class members than for the defendants in terms of making sure that each person is getting their pro rata share. And that often in practical terms goes semi out the window once you're at the end of the case. So I think this is arguably an example of the federal courts choosing to look at one side of the injustice and not the other.
Is that a good place to end on, or Matt, do you have a response?
I would just go back to say that I guess in terms of the actual amount who actually go forward and actually request as part of the claims process, et cetera. Actually, just let me make a more general comment. I think that we were discussing earlier about the claim administration process altogether. I think all parties would benefit if there, in terms of during class certification, if there were more concrete steps or plans in terms of how the claims process would actually be executed. Because I think even a lot of these issues we're talking about today in terms of ASICL, you had plaintiffs coming in saying, no, we can handle it through the claims process. And there was some rough idea of what that might be, but the court even went on to say, we have no idea what this actually means at the end of formula, et cetera. So I think everyone would be better served, not only in terms of potential recovery for people getting the claims or filing claims, et cetera, but if we actually had specific proposals in terms of how to handle the claims administration process, and that was also part of the actual class certification briefing and decision making. Because again, a lot of these overlap, and at least what I see now is they'll handle during claims administration without any actual guidance as to whether that's the case. And I also do think there's something inherently unfair that if you have someone who gets overcompensated that means that someone else gets undercompensated. Depending. Now, if there's a lot left in the class, maybe, but still, I think you want to know what that formula is, and even if it's not, who at the end of the day, how much money is left, but how the formula is actually apportioned, I think that matters.
Okay. Oh, another question.
I'm Dave. I work with Nathaniel, so you know where my sympathies lie.
Yeah, I'm like, oh, this guy. Yeah.
But yeah, so one other question I had about that. I mean, my instinct when I hear that decision is, what's wrong with just discounting all the damages 90%, right? Letting the whole class in and just discounting it. If you covered that, I apologize. I might have lost something in the beginning there. So I'd be curious what the legal or policy reasons are for objecting to that approach. And secondly, we talked about, the policy reasons behind Rule 23 being the compensation of injured consumers. But of course, there's other reasons too, right? There's deterrence, and there's other reasons why we enforce the law in the way that we do. And so how might those other policy reasons behind the law be affected by this decision?
Well, I think in a sense you're simply articulating Nathaniel's statement earlier that oftentimes the judicial system knowingly gets it wrong with respect to Illinois brick. I would say that, well, I'm not an attorney, so I should be careful how I tread here. But as an economist, I think that it can be demonstrated that certain proposed class members may not have been injured, and the defendants should have the ability to point that out and should have the ability to say, based on the facts of this case, it's unclear how this particular class member was injured, and compensating that class member would result to a windfall to that individual. And it's my understanding of damages that damages aren't to represent a windfall. Now, you might argue that damages act as a deterrent, which is arguably embedded in Illinois brick.
I think I would also say, too, it fundamentally changes the nature of what a class action is, or at least from the defense side, which is the collection of individual claims. And if you have a 10% who are uninjured, you're allowing them to come forward and get recovery when they were, in fact, not actually injured. And they couldn't have done that on their own by going into court. So I think as a procedural matter, I mean, it's one thing if we want to, I guess, try to change the law, but in terms of just being procedural, it's changing the very nature of what a class action is, which is a collection of individual claims being adjudicated at the same time.
And that's certainly true, but I think that lawyers are really experts at making what is an exercise in approximation sound as though it has clearly defined, absolutely true boundaries. Which, if I define a class as a class of men versus a class of people with XY chromosomes, there's a lot of overlap there, but it's not going to be 100%. And when we are defining classes based on objective criteria rather than fail-safe definitions, which if we allowed fail-safe definitions, we're basically cutting out the class cert process entirely and going straight to merits. We don't do that. So because we vaunt the importance of objective criteria and administrative feasibility and ascertainability and all those long words that lawyers create to, pretend that approximation is an exact science, I just think it's so selective to say, well, we know there's a class here. We know this conduct allegedly occurred. We know that this happened and the damage was X. But the fact that we're going to get it a little wrong here and a little wrong there is unacceptable.
And I would just come back, and what I would say in response is, class action isn't the only mechanism in which you can recover. That you can have states, attorney general, on their own accord coming forward with their own actions on behalf of residents of their state to recover, and do it on an aggregate basis where you sidestep all of these issues. You can have a regulatory proceeding where for potential to remedy or to fine for potential wrongdoing. It doesn't have to be just a class action. And so I would say there are other mechanisms out there beyond just plaintiff's class actions that can address this when you get into situations such as this where it's not clearly defined and you're not able to identify who's actually injured.
We also have weird mechanisms like cypre, that I think step sort of in loco class action in the way we usually think of it.
But I like mine better.
Yes.
So I think that that uses up all of our time for today. So thank you so much. And then we have one more panel remaining. I thought you guys were going to close over